Ms. Greenberg.
Thank you. May it please the Court. This case is a really good example of why you have 33E review. This is a very troubling conviction. There's not a lot here that will please the Court. The fact pattern is very peculiar. If I look at all states and all federal cases, I'm not finding any cases where the witness picks and reaffirms a picture of a suspect and then they arrest somebody else. And that fact pattern where a witness says, looks at a picture, say a picture of Justice Spina, and says, that's the perpetrator, John Graney, and looks again at a picture of Justice Spina and says, that's the perpetrator, he said his name was Graney, where they then go out and arrest Graney. Usually they arrest Spina because they looked at Spina's picture.
Why am I being dragged into this?
It's your job.
Well,
And that's really what we have here. I think if we had people applying for an arrest warrant, which we don't have here, or a search warrant, and they said, here's the picture of the guy the witness picked, she said his name is this, they wouldn't then go out and issue an arrest warrant properly for the name. They'd pick it out for the picture.
Well, I have a question. It's something that I don't quite understand. Trans identification of the photo.
Yes.
Why isn't that an act?
I'm sorry?
Why isn't her identification of the photo an act?
Oh, and not a
And not
statement.
Right, and not a statement.
It's
Haven't we said that that's the whole, I may be confused, but haven't we said the whole reason that we allow in all of this identification testimony is because identification is an act?
Well, you know, it's an interesting question. It's an interesting question what a jury would think. You're like back there in the jurisprudence behind the rules of evidence, but I think in terms of what a jury is expected to understand, a person who says something is making a statement.
Well, we don't, our rules of evidence aren't guided by what juries would understand or not. Our rules of evidence are what they are for whatever reason.
Right.
And, I mean, isn't that our law, that an identification is an act?
An identification is an act.
Okay, so if so, why is her identification a prior inconsistent statement? It's just I mean, didn't it come in for substantive evidence? I mean,
No.
No, it wasn't permitted in, correct?
Came in as a prior inconsistent
it came
statement.
in.
I mean, he instructed that it
Yes.
was, I'm sorry, it
Yes.
came in, but he instructed the jury, or she instructed the
Yes,
jury.
that's exactly right.
That it was not substantive. They could take
Right.
it as a, yeah.
The jury was instructed it could not be admitted substantively.
And it was admitted as a prior inconsistent statement
Right.
only.
Yes. That was what the jury was told. And
And there was no objection to that.
I'm sorry, not. Regrettably, as we say, not. And the evidence in this case is otherwise startling in its absence of inculpatory evidence. There were several co-defendants in this case. It's a very messy, bloody stabbing. They do DNA. They find the blood of the victim, of course, the blood of the co-defendant, but there's no match for Mr. Choeurn. The fact pattern's complicated. All the perpetrators are together at a party, and there's a witness from the party, I'm sorry, Fen Chan is his name, and he knows the person known as BJ very well, and they bring him to court, and the Commonwealth says he's going to identify the defendant as the person known as BJ, and they put him on the stand, and he can't. identify the person in the courtroom as the person they all knew as the perpetrator and the guy known as BJ. He can't do it. So there's Fen Chan, he knows BJ, and it isn't the guy in the courtroom.
Is there any evidence linking Knack to this crime?
The evidence that links Knack to the crime is the witness Tran picks out his picture.
And nothing else?
Nothing else.
No one else identified him as part of this group who attacked the
No,
the
but
victim?
nobody identifies BJ either. I mean, I'm not Knack's lawyer. I'm not saying whether or not the Commonwealth could make a case against Knack. They have a real problem, but nobody tested the DNA against Knack's DNA, but what you do have is a person consistently saying, that's BJ. I know him. That's him in the picture. And then you have the other person knowing him, looking at Choeurn and not able to say, that's BJ.
And there was evidence that BJ, or that Knack, I can't remember which one, they called each other by each other's names, did they not?
It's very confusing. I mean, the Commonwealth will say that the record clearly reflects that Bull says he's Knack, but not Knack says he's Bull, but it's not clear. It appears it's equally possible to draw the inference that Knack uses the name Bull. The police have pictures of Knack that they believe are Bull.
So how can you say counsel was ineffective when he mounts a pretty good mistaken identification defense, gets a good instruction on that, got the witness confusion over who's in the picture, who's not in the picture? How is that ineffective? I mean, you're not entitled to a perfect lawyering.
No, but you're entitled to the exclusion in Massachusetts of an unreliable and suggestive identification.
Well, maybe
you're
you
also
are, maybe
entitled
you're not.
federally. Well, the question is where the witness, and again, I'm not able to find any case law which deals with this, and the case law cited by the Commonwealth doesn't address this fact pattern, where a witness persistently identifies someone else as the perpetrator, and then only then comes into court and is faced with the one-man show-up.
And this woman was sitting right next to BJ in the car.
Right, and she looked at
So
the...
she obviously knows who he is.
And she picked the picture in Knack. She said, that's him, that's BJ.
Was there a picture of the defendant in the photo array?
It does not appear so, but the record, I don't think so. The record is not clear on it, but I can represent, I
And
don't
she picked him
believe
out of
so.
a lineup, did she not?
No,
No, I thought she did.
she picks Knack.
Out of the lineup?
There's a photo array.
No.
She picks
okay. I was talking a physical lineup.
No, there is no physical lineup. She picks Knack consistently
that.
from the photo array. None of the other witnesses who were able to identify Pav Auer, the co-defendant, so they're not shaky witnesses. Jeremy Richardson, who looks at them both, is able to pick Pav Auer out of a lineup, but he's not able to pick Choeurn. But the really troubling one is Fen Chan, because he knows BJ, and he can't say it's Choeurn. So how is that possible, unless the person that they know is BJ is not Bull?
How do you deal with her testimony that of Clan, it's Ms. Clan,
Yes.
Clan testimony, that she had spent, so much time during the summer of 2001, 4 times, and she'd spent a day with him, and as Justice Cowan, I think, said, she's sitting in the car next to him, she's sitting in the courtroom next to him.
She definitely knows a guy who calls himself BJ, and she looked at a photo array and she said, that's him, and she pointed to Knack.
No, but she was there, correct?
Right.
She's a witness.
Yes.
She knows the person that she spent time with.
Right.
So she knows him. This is not a
Yes.
photo array.
Yes.
Photos can sometimes, some photographs of me are wonderful, others are awful. But she's there, and he's in the courtroom. He's in the courtroom. The person that she...
Yeah, it's very troubling. You could look at it either of two ways. You could say a live guy is always more accurate than a series of pictures. The other way you could say is a fair photo array is a lot more accurate than a one-man show-up of a guy who's basically...
And it's closer to the time.
Right, you could say that. But you could also say, you could say what's more reliable, a photo array or a single person, one-man show-up of a guy who's in the
Is there
dock.
anything in the record, Ms. Greenberg, that, permits a photo comparison of the defendant and the person picked out?
They're in the back of the
Yeah,
book.
if you
And
look
did
at-
anybody ever notice that they don't look at all alike?
Yeah, if you look at my reply brief, with my
Okay.
child's assistant, scanned in the two photo pictures.
Okay.
One is a really little tiny guy with a weird face, and the other is a 170-pound guy. They're different sizes, their faces are different, their ears are different, their eyes are different. They're clearly two different guys.
What is the error on which you're seeking to have us reverse the case?
Well, here's what I'd like you to say, that, I mean, when I look at a case like this, I say, how did this come out wrong? I mean,
Excuse me, in your
Yes,
reply brief?
yes, you have a reply brief. This case, yes.
Yeah, but mine doesn't have pictures.
Oh, no.
Wait a minute, I have it.
No, mine doesn't have, oh, no, I'm terribly sorry, it does. It does.
Does it-
Okay, it
A
does.
1,000 words, right? Here are the errors I draw to the court's attention when I ask the court to consider how this could happen in the absence of DNA, in the denial of the inability of the other eyewitnesses who know BJ to say it's Mr. Choeurn. I mean, I think what happened is, first of all, the jury was told they couldn't substantively consider her identification of Knack. Regrettably, no objection was lodged.
But they could consider it for purposes of impeaching her credibility.
Right.
Okay.
And then I say, it's because once she picked out Knack and said, that's the guy, in a fair photo array, there shouldn't have been, I mean, the literature doesn't always say, and the Commonwealth is right, we don't absolutely preclude an in-court identification of a defendant for the first time.
Explain something to me.
Yes.
Qualitatively, what is the difference between the way this case was presented to the jury, which I take it was mistaken identification, in which the in-court identification is impeached by the fact that, as you've been saying, consistently, up until the time of trial, she's identified the wrong person. What's the difference between that and if the trial had proceeded in the way you're suggesting, which is the third-party culprit defense, which is, my client didn't do it, Knack, his brother, did it?
Well, I'm saying what they are arguing is Knack, his brother, did it. The Commonwealth tries to distinguish a mistaken identification defense from a third-party defense, but I agree with you. It's really the same thing, except that a chunk of the evidence was the substantive evidence of the third party was removed.
Are you telling me that that Ms. Tran did not see the defendant until she appeared to testify before the jury?
It would appear from the trial record before us that that could be so, being as she says, I know BJ, but the man she knows as BJ, she picks out a picture of Knack.
No, but I leave that aside. So she had not seen this defendant?
It would appear from the trial record that she had not. She knew, at least, it was a question for the jury to consider. I mean, I don't...
Well, she had spent a day with him.
She had spent the day many days with the person she knew as BJ.
No. Here's my question. Is there anything to suggest that she knew two things? I think you answered the question, that she hadn't seen this defendant. Is there anything to suggest that she knew from the Commonwealth or somebody else that the person that she had picked out from the photo array was not the person who was on trial?
No.
No, because the police
No.
apparently and the DA's office didn't realize it.
No.
Isn't that part of the problem?
No. Yes.
Nobody realized
It's
until
a
the middle of
giant
the trial.
snafu.
But wasn't it apparent at trial that she had picked out the wrong wasn't it apparent at trial that the person she identified as BJ was not the guy that was sitting there at trial?
Not until after she finished testifying, and I read in the Commonwealth's brief, apparently went home. I mean, I don't see anywhere in the record
Well, she was
that...
cross-examined on the
Correct.
fact that she had made an identification of his brother.
No.
No, she wasn't. That
No.
was the whole thing. And that's why
It's
I
very
think you
peculiar.
you couldn't claim ineffective assistance here because the defense attorney picked a very clever strategy. He waited until she had gone home. She was from out of state at this point, and he only attempted to impeach her, as it were, when the police officer who did the array with Ms. Tran was on the stand, and then to everybody's surprise except the defense attorneys, it was shown that the picture that Ms. Tran picked was not the defendant in the courtroom. Am I correct? Is that right?
Well, this is what the Commonwealth argues. Whether or not that's the case is not
Well, do you
clear.
have, is there anything in the record that would indicate otherwise?
It's
That the
not-
facts are other than I just stated them?
It's not apparent from the record, and at what time this became known to anybody.
All right, it wasn't brought out in the trial until the police officer was on the
Right.
stand and the
Right.
defense lawyer was cross-examining him after the identification witness had left the courtroom and the state.
But assuming it were correct, that the strategy would not...
That's a very high-risk strategy. I mean, it may be clever, but if you
It's
don't...
indefensible because where the Commonwealth argue, it's indefensible within the meaning of Safarian and Strickland because the witness is not unavailable further to testify. Maybe she went home, but she could come back, and the Commonwealth was certainly free here, and I write this in my reply brief.
Right.
If she had some explanation, she would have been there to testify some more. There was no reason the Commonwealth couldn't, at that point in the trial, simply call Tran again to say, I was mistaken before, if indeed she was able to say that. She didn't die between day 3 and day 4. She was available to the Commonwealth for recall.
But in any event, I mean, if even if she were available to be recalled, it seems to me that she's the one that has to explain this for better or
Right.
for worse.
So this is not a reasonable defense strategy, the one propounded by the Commonwealth. If it were the strategy, it's ineffective assistance. I want to just say the one thing, particularly where the credibility of Tran is key, and it does, then it's really, and given this question, could they have brought her back, where the prosecutor argues she wouldn't be here in court today unless she were here to tell the truth. We really do have a problem, and we have preserved error. It's very troubling, this. I give it to you.
Thank you, Ms. Greenberg.
Thank you.
Ms. Smith?
Good morning. If it pleases the Court, Loretta Smith, Assistant District Attorney for Middlesex.
Ms. Smith, did anybody before trial ever take the picture that Ms. Tran had identified and look at the picture and look at the defendant?
I'm sure that they did.
They did?
I'm sure that someone looked at them at some point. They had the booking photo of the defendant on the day
Well,
he was
how could
arrested.
anybody say that the picture of one brother looked at all, I mean, I've seen sometimes when the pictures look alike, but how could anybody say the picture of one looked like the picture of the other in this case?
Well,
Forget the height and the weight.
I can tell you that when I looked at the photo array, and I looked at the picture of the booking photo, and said to myself, if I had to pick this man out of the array, you would have picked the man that she picked. And
Okay,
and
but if you
need to look
take
at
that picture and compare it to the booking photo of the defendant in this case, do they look alike?
Personally, I think they do look alike. They're 6 years apart, and a big gain of weight is what the difference is.
Did the Commonwealth introduce the photograph, the pretrial identification photograph in evidence?
Yes, the photo array was in evidence, as was the individual photo from the array.
And the Commonwealth introduced that evidence?
The Commonwealth believed that the picture was a picture of the
The
defendant.
defendant.
And
The
that's,
Commonwealth believed the picture was a picture of the defendant?
yes, and let me explain why.
And
And
he
how.
lost weight after 5 years.
He gained weight.
Or gained weight.
Did they have his name?
Yes, and let me explain.
It's the same name.
You can give me an explanation, but
But there is an explanation, and the explanation is this. When Tran told the officers that the person she knew as BJ was the person involved in the stabbing, they went and found out who BJ was. They come with the name Bull Choeurn. They run his Board of Probation record. They find that he has an alias of Knack Choeurn. They run Knack Choeurn
you're
for
just digging yourself into a big hole, Ms. Smith.
I'm telling you what happened. They run Knack Choeurn's name through the Board of Probation system. They don't turn up any record. So they believe that Knack Choeurn is an alias used by Bull Choeurn.
But it could also be the other way around, that BJ is the name used by both, or maybe by Knack Choeurn.
But when you run the name Knack Choeurn, you don't get a Board of
what
Probation
does that
record
mean?
at all.
But they commenced the investigation because the name they were given was not Choeurn, Bowl, or Knack. it was BJ,
Correct.
correct? So BJ,
Is the name that Choeurn uses. There is nothing in the evidence to suggest that Knack Choeurn ever used BJ as an
all right,
alias.
is there any evidence, is there any evidence that Knack Choeurn used the alias BJ?
Absolutely
Okay, do we
none.
know how common the name Choeurn is among this segment of the population?
I do not know.
Okay, so it could be as common as Smith, your name,
It
or
could.
Jones. There could be tons of Choeurns, so they take this one Choeurn and they say, well, he's BJ because he has that last name.
No, they say he's BJ because they do an investigation to find out who is referred to in the community as BJ, and BJ is the person named Choeurn.
Then why is there nobody at trial who can come in at trial and say, other than Ms. Tran, who can come in and say, this is BJ? If they do that investigation, who do they talk to? Who
The
doesn't come in
officer
at trial?
testified that he...
Not the officer.
Well,
Who-
the evidence came in that from the officer that Choeurn was known as BJ.
how did that evidence come in?
It came in part of the Commonwealth's case.
It was direct knowledge of the officer?
No, he explained the investigation had been done and that was...
But how does that come in? I
Well,
mean, it's critical, right? It's critical, because let's assume that BJ, in fact, wasn't Choeurn, it was Knack Choeurn. Just assume, right? I mean, who is telling the officer that BJ is Choeurn as opposed to Knack Choeurn? How does that evidence get before the jury? They may, I take it there
It
was no...
did.
Was it on
I take it there was
cross-examination?
no. I take
No.
it there was no objection. I take that.
No.
But how can it come in? I mean, tell me now. Was it error to let it in? Assuming I objection, Your Honor.
No.
It was not error. What's the basis to get it in? I'm defense counsel. I've objected. What's the basis of the police officer testifying?
Well, it was a result of his investigation. That's what he learned. And I think the reason it came in was it was clear that we could have brought in other witnesses to testify.
Okay, but then once
I'm
there was
sorry.
this problem, when the defense lawyer cross-examined your officer, then why the Commonwealth didn't bring in any other witnesses to strengthen its case, to show that everybody in the community, or at
Or
least
one
some,
person.
knew this person was BJ?
Other than Tran.
Right.
No.
And she's gone, and she's already made a mess of it. Why didn't they, if there are all these people in the community who know that this man is BJ, why didn't someone come in then in your rebuttal case?
I don't know the answer to that, but I can assume that since Ms. Tran was threatened, maybe other people did not feel like coming forward.
Did that officer know that Ms. Tran had identified the wrong person before trial?
No, because they all believed that the picture of Knack Choeurn
So this-
was a picture of
Go
BJ,
ahead.
6 years old.
So
That's-
your,
that's-
your position is this was a brilliant stroke on the part of defense counsel.
I thought it was, actually.
He ambushed the Commonwealth.
He certainly did, and I thought anything but ineffective assistance of
So the
counsel.
strongest thing you had going for you at trial, and correct me if I'm wrong, is Tran consistently saying it was BJ, and Tran identifying BJ in the courtroom. That's what you had.
Correct.
That's all you had, in fact.
That's
Yes,
all
and it
you-
was for the jury to decide.
Yes, but we've now got evidence that if the jury is told, and I still don't see the basis of it, BJ is known in the community as Choeurn. I mean, when the police officer doesn't even know that there are two men, right? I mean, I'm not saying that the police officer, he might have been told that, but the police officer apparently doesn't know that they're two brothers. Correct?
The police officer believes that the name Knack Choeurn is an alias used by Choeurn.
So he thinks there's-
He does not know that Knack Choeurn exists.
So when he says BJ was Choeurn, he might have been saying BJ was the defendant because he thinks there's only one.
That
He
is
thinks
correct.
there's only
He thinks
one.
there is one person.
So nobody said to him, now, was BJ Bowl or Knack? I don't know what the officer would have said. He would have said, well, he was the one.
Well, by the time they're doing the investigation as to determine who is BJ that Tran is referring to, They are told that BJ is a person by the name of Choeurn. They locate Choeurn, they arrest Choeurn.
And where was he arrested?
When was he arrested?
No, where?
Where? I don't remember.
Did he live with his brother?
No, he was not arrested with his brother.
No, did he live with his brother?
I do not know.
You told me, I think, at the beginning, that the police did not know before trial that these were pictures of two different people, that they thought it was the same person.
Correct.
Okay, what about their dates of birth? They've got mugshots of both people. Mugshots have identifying information, including dates of birth.
It's not uncommon, in fact,
Right.
to see aliases with different dates of birth on a
But
border
these two
probation
people,
record.
Nobody ever, with the difference in their faces, nobody ever took a look at the dates of birth and said, maybe this isn't the right guy, the same guy?
I do not believe they did.
So the police investigator looked like a fool by the time he was cross-examined.
There's certainly a lot to that.
So so we're here on ineffective assistance of counsel, and that goes back to my question, and that is my thought, actually, of how can you say it's ineffective when the trial lawyer used an obviously very clever and persuasive strategy that in the last analysis didn't work?
I don't think you can, Your Honor.
Because 12 people sat there, listened to Ms. Tran, looked at her, sized it all up, and concluded beyond a reasonable doubt that she was believable.
And more than just looking at Ms. Tran, they looked at the defendant for 5 days, 5.5 days, and they looked at the picture repeatedly.
Could I ask you this question?
Yes.
The police officer testified before or after Ms. Tran had left? I mean, before or after Ms. Tran had testified?
After.
If this was a calculated strategy by the defense attorney, why would the defense attorney not object to what is pretty damning testimony, which is BJ is Choeurn, not Knack Choeurn, Choeurn? Why would he not object to that? I mean, if the strategy is to make the police officer look like a fool, to make them look as if they don't know the difference, I mean, this is hearsay evidence. Why would you not jump to your feet and say, that can't go before the jury, because that's the link? In other words, if the police find out from the community, BJ is Bowl, and if she says, this is BJ, I was with him, that testimony of the police officer, now we don't have the credibility of Ms. Tran at issue. Now we have the whole strategy about to go down the tubes because a perfectly respectable police officer tells the jury, this is BJ, because there's a lot of discussion about BJ. There isn't a lot of discussion about Bowl and Knack Choeurn, correct? It's BJ, BJ, BJ all the way.
The reason it's BJ is that that's the name Tran knew this gentleman by.
But
She did not know Choeurn.
But that's what Tran says. But here, the police officer is saying, it's not just Tran, it's the whole community. BJ is Choeurn.
Is the answer to the Chief Justice's question perhaps that the defense attorney doesn't want to give away a strategy at this point? He wants to
that's
wait
why
and
I asked-
ambush the police officer.
I think that's correct, and that's what he
How can he
did.
ambush the police officer if she's
He did.
gone?
Because he doesn't want to give away to the Commonwealth what's coming up.
No, I'm not talking about
Tran.
I'm not talking about Tran. I'm talking about when
No.
the police officer's on the stand. The police officers. I mean, why would he not object to that?
Because he's going to put it in himself anyway, isn't he?
Well, which police officer testified to the fact that Bowl was known as BJ? Was it the same officer who testified about the array?
Yes, Trooper Hunt.
So the key to the whole thing was right under the officer's nose. The officer's testifying about Knack and BJ and hasn't put it all together yet.
Actually, during his direct exam, he doesn't mention Knack at all.
Of
None
course
of this
he doesn't.
comes up at all.
Of course he
So when he
doesn't.
gets cross-examined, he gets hit with all this, and by that time, Tran is gone, correct? Off the
Correct.
stand and probably gone from the courthouse.
She's been gone for days.
Which makes imminent sense because, for the defense lawyer to do this, because if, once this thing developed in cross-exam, they could bring her back in rebuttal. And they didn't want, and the Commonwealth could have brought her back in rebuttal, but she's long gone.
She is long
So the defense lawyer
gone.
is, it seems to me, doing a very reasonable strategy here.
Is there an affidavit from defense counsel in this case?
No, there is not.
How does this I think it seems to me what we're left
Yeah,
with
there
is
was
that
seeing
Ms.
that.
Tran identified the defendant as the killer, and that's it. And the jury believed that, and we can't usurp the jury's function. But how does the judge's instruction play into this? The fact that he said you can only use it as a prior inconsistent statement.
That didn't happen. I'm sorry to say that didn't happen. What happened was, because the Commonwealth believed the picture was a picture of the defendant, an old picture of the defendant. When Tran testified that, here's the photo array, I picked this man out of the photo array as BJ, that came in substantively. The Commonwealth didn't ask for a limiting instruction on its own evidence. The Commonwealth believed, in fact, that that was an old picture of BJ. So the evidence came in substantively. The only way you can get to the defense argument that it didn't is that the two-sentence standard instructions on prior inconsistent statements.
Okay, were they tied in any way to Tran's prior identification?
No, the prior...
Okay, so that's my first question to Ms. Greenberg. That wasn't it a prior act, so it was in for all purposes. But she answered to me, no, she said it was in only that the judge limited it.
The judge never said anything about it.
The judge never limited it. Okay.
Never limited it. He gave the standard instruction on prior inconsistent
So
statements.
it was in for substantive purposes.
It was in for
Okay.
substantive purposes.
So that's even better for the defense.
It is, and the defense argued vigorously, that was the only defense, that this was a mistaken identification case. Did not argue it was a third-party culprit case where they had taken on an additional burden of pointing their finger at someone else, but argued strenuously that this was a mistaken identification, that Tran was mistaken, not that she was lying, but that she was mistaken.
So when the judge instructed on prior inconsistent statement is being used only to impeach, he never said that Tran's prior identification of Knack was a prior inconsistent statement.
He did not.
So then there's much ado about nothing.
That is correct. He, in fact, talked about the prior misidentification twice, and they're both cited in my brief at pages 24 and 26, where he says, take into account that a witness ever tried and failed to make an identification or identified made an inconsistent identification.
Well, that goes to the honest mistaken identification.
He gave that
which
instruction.
is a substantive issue.
He gave that instruction. He also gave the instruction about her picking out the wrong photo in connection with the limited use in which the evidence of incarceration of BJ was offered by the defendant to show that that picture could not have been him because he was in jail. Thank you very much.
Thank you, Ms. Smith.